Recorded at the studios of Chicago Public Media, WBEZ, this is Stages to Success. The drive to excel is universal, as is the pride in a job well done. Whether you're staring down a decision maker for a multi-million-dollar contract, a television camera or microphone, a negotiating adversary, or an irate conductor, the pressure to perform can be exhilarating and exhausting. Join me and meet great storytellers from music and business. Stages to Success is brought to you by
NICAR, the Northern Illinois Commercial Association of Realtors.
Today's guest is real estate attorney Jim Hochman of Shane Banks. Jim is a frequent teacher in continuing education for commercial real estate brokers and a legal expert and practitioner in everything imaginable in real estate. We began our interview with the beginning of Jim's career, which started somewhere that may surprise you. I was interested when you were, maybe you were 2 or 3 classes in with us, and there was a young woman who was a broker who actually worked at the USO. And she came up and, thanked you for your military service, which, was interesting. I think you might have mentioned it in one of the classes along the way. And then you wrote to me that you actually served 22 years?
I had 3 years active duty with the United States Navy and an additional 19 years in the Naval Reserve. That's correct.
Okay, so you weren't an attorney when you did your 3 years of hard labor for the Navy, correct?
It was a mix. I got my assignment out of officer candidate school based on a pretty strong LSAT score, so I served as the assistant staff judge advocate for Recruit Training Command at Great Lakes. So I worked for lawyers and with lawyers and probably tried about 300 cases in the Navy before going to law school.
How does that work? How do you get to be on the operational end of the law for the U.S. Navy without going to law school?
I'm not sure. The Uniform Code of Military Justice and the Judge Advocate General Manual allowed a non-lawyer to serve as trial counsel or prosecuting attorney for administrative discharge proceedings, which I ran for several years as trial counsel.
Okay.
And I was also given the opportunity to serve as defense counsel on summary courts-martial, which are the lower disciplinary end of the spectrum.
And how old were you at this time?
22 to about 25.
So tell me, do you have to wear the dress blues when you're in the Judge Advocate General's proceedings?
I imagine I was wearing dress uniform most of the time.
Yeah, so it's
at least in a proceeding.
So it's sort of like the Jones Lang LaSalle guys in their black suits and their navy blue suits, no matter where they go, no matter what they do, right? So you were actually, I can see now from your questions why you found law school and real estate law appealing, because you're already really serving in a lawyerly capacity before you even went to law school.
I had a pretty good taste of the profession, which gave me a perspective in law school that might have been different than some of my classmates. Yeah.
And so did you ever get a taste of what we might consider real estate or property law when you were in the military, or was it all these disciplinary and court-martial type cases?
I did have some experience doing real estate legal work for the Navy, but that came much later in my career. That was actually 1991 and 1992, my last 2 assignments in the Naval Reserve. That was well after law school and well after many years of practice.
Did they have anything to do with munitions or former sites? I've heard of that sort of stuff coming up with the services.
One of my assignments had to do with one of the base closings in the Pacific and following the federal law and guidelines on closing a base and offering other federal agencies the opportunity to own or use the facility or the land before it could be sold to the private sector.
And did anybody pick up the right? Let's call it a right of first offer. Did any other government agency pick up the right to the foreign real estate?
I can't answer that because I wasn't on duty long enough.
Oh,
Each of these was 2-week assignments to work for U.S. Sink Pack. Happened to be a 4-star Navy admiral in charge of all of the Pacific, and they, oddly enough, sought me out to come serve as a real estate attorney for a 2-week stretch in 91 and again in 92.
well, I mean, do they have the sort of rights over land in the Pacific like a consulate would in Washington? Is it sort of a nation within a nation kind of thing?
I believe these properties were in U.S. territories.
I get it.
Might have been Guam, might have been somewhere else,
And
something like that.
yeah, Guam's like Puerto Rico, right? It's you're a citizen if you live there.
I think so, but it's not a state.
Right. We had some interesting training with you where you would talk about the residential real estate part of the equation for the great majority of the people taking the test. However, in our class was a very large contingent of commercial real estate managing brokers like me. And that's what made it interesting because you applied it constantly, yet we were constantly going back and forth between the teaching that you obviously had to do on the residential testing side of the equation and the way you explained the casework to those of us who just don't work with those terminologies, those expectations. Talk a little bit about the balance that you see with this crazy monster that we have of one license serving two disciplines, residential and commercial real estate.
In each of the 51 jurisdictions, the 50 states and the District of Columbia, there is one license act,
Yes.
which governs all real estate brokerage. The real estate commissions are basically dealing with the majority of their licensees who are residential practitioners.
Of course.
And that it is considered that commercial real estate is a subset. So what commercial real estate brokers do for consumer protection and observing license law and continuing education still has to comply with what the Real Estate License Act indicates and what the individual real estate commission decides is required for continuing education or for licensing for that matter.
Yes.
What I try to do in my continuing ed classes, and you probably noticed that most of the attendees were commercial real estate brokers, is I try and illustrate the license law with commercial real estate transactional analogies so that my people learn what they have to learn or are refreshed and understand what they have to understand.
Mm-hmm.
Even though what they're doing isn't what the state thinks they're doing.
Right. Yeah, and that's one thing I really enjoyed about your classes. I sort of stumbled into them through Inland, where I'd done a lot of renewal of licenses over the years using a book that you take home or online, which was just too tedious for words. And I thought, I'm just going to go to the class. And the guy that ran Inland said, you're going to like this class. You're going to get Jim Hochman. And you would do almost case study explanation. I remember you had code names for the ethical issues that came up. I still remember Captain Bligh. You called somebody Captain Bligh.
Well, Captain Bligh was named after a fellow similarly named who had a pivotal role in a transaction that led to some litigation that lasted 10 years.
Right, and it was really interesting.
Well, you're very kind. A lawyer who gets to talk about the actual cases he's handled really has it pretty easy.
Well, you mentioned that you have worked on commercial broker lien statutes in 34 states. Now, are you talking about the kind of lien waiver that I have to sign as a tenant broker when I collect a commission on an office lease? What exactly are you talking about? Okay.
Back in 1990, the Illinois commercial brokers thought, why don't we have lien rights? Why can't we get some leverage or at least level the playing field to collect our commissions?
Yes.
Sophisticated landlords, sophisticated sellers would take advantage of brokers and basically say, if your commission's $100,000, I'll pay you $50 now, but if you're going to sue me, you're going to have to spend money and you're going to have to wait years and years and years. So it's a net gain if you take 50 right now.
Right.
So a bunch of us got together in Illinois and thought we really ought to do something about this. We began to work with the Illinois Association of Realtors in a process that took about 2 years for completion in a couple of different legislative sessions. But we helped draft and support and lobby for the Illinois Commercial Real Estate Broker Lien Right, which was the first significant broker lien act in the U.S., the first of what are now 34 different statutes.
Well, thank you very much. And it's actually a fairly simple procedure to put a lien against a building.
You need to do it right, and that involves some care, because if you're going to put the lien on the property and have to foreclose it, you're going to have to win a lawsuit based on strictly following a statute.
Mm-hmm.
So there is a certain amount of care that goes into drafting the commercial real estate broker notice of lien and service on the owner. There's a certain amount of strategy in the use of a broker lien or the threat of a lien, and then hopefully the exchange of a lien release or a lien waiver for payment of the commission.
Right.
Sometimes that happens at closing. Sometimes it takes years.
Yeah. I mean, I frequently have to sign a lien waiver for any commission that comes in, say over $10,000. It's going to be issued to me by the owner of the building. Were you hired by us? Were you hired by people on the tenant side of the equation as you were worried about the correct way to formulate the statute to get these lien rights activated? Who hired you to do this?
Nobody hired me. I was in-house with CBRE, then Coldwell Banker Commercial.
Yes.
And I considered that to be something that would certainly benefit my employer and my clients.
Mm-hmm.
So I volunteered. I was the sole lawyer working on it from the broker's side, along with a marvelous gentleman by the name of Steve Bohennick, who was outside counsel to the Illinois Association of Realtors. I'll give you a little history. Coldwell Banker Commercial was owned by Sears until 1989, when an employee-led leveraged buyout purchased the company from Sears. With outside financing, I seem to remember Banca Summa Tumo, and a whole lot of equity raised within the company. We executives chipped in a bunch of real money. We were given some stock and retention bonuses, and we operated the company through some dark days, 89 through 91. Things got rough. The market turned. There was actually some question as to whether this employee-owned company would survive in a down market. Of course, we did. Went public many years later. Many of us had earned stock, taken stock in bonuses, taken our bonuses in stock. I had bought stock from folks who were leaving the company. We, a very loyal, small group of Coldwell Banker Commercial and then CB Commercial folks, basically put our money where our mouths were and bought the company and owned the company and are very pleased to see it thriving today. CBRE and its predecessor names, the chairman I first worked for, Frank Mahoney, and then Jim Didion, always said, if you treat the customer's interests as foremost, everything else will take care of itself.
Yep.
And they were right, and it does. You don't, and this is my saying, you never go wrong doing the right thing.
I brought up a question to you in class that I watched. I watched all the residential brokers duck for cover as though I'd pulled out a loaded weapon in the class, because in my capacity as the broker for Chicago Public Radio's reporter stations, all their reporter bureaus I represented, I would be told a very strict demographic. Here, we're doing stories from the South Side. We need to be in a highly dense black neighborhood. Now we're doing the Humboldt Park Bureau. We need a Spanish-speaking neighborhood to get the stories. Now we're doing the Devon Bureau, where we need a majority Muslim population in order to get to the sources of these stories. And I brought that up in class because it ran so completely counter to how the fair housing and all those sorts of residential controls, and I'll say correctly minded controls, it ran so counter to that thinking. But I wanted to know, why is it okay? And you brought up a case study of a bagel store that had to locate, or bagel franchise that had to locate.
Yeah.
Can you share that case study?
Well, sure. Certainly, when you are looking at a neighborhood, and the demographics of the neighborhood are important for your client in a positive way, you're not discriminating against any minorities. You're simply going where the business is or the location is important for the client. The story that I think you're referring to was the client was Einstein Bagels, and a terrific broker that worked for CB back in the day was representing them. And he went to the company and said, I need a map of the Chicago area, and I want to know where all the temples and synagogues are, because I'm sure that where Jews worship is near where they live.
Yep.
And where they live, they will buy and eat bagels. So in order to assist Einstein Bagels in locating its stores, I need to know where the temples and the synagogues are. And of course, like your residential broker classmates, the demographic people at CB shrunk back in horror over the request. And I got a call, and it gave me quite a laugh. And I explained to them that the information that our broker sought was perfectly reasonable as a request, and the kind of thing that the demographic people should provide. But then I said, I don't think that this particular brand of bagels is going to sell very well with Jews, because they're not really Jewish bagels.
You're reminding me of the Taco Bell fiasco that's happening in Pilsen right now.
Well,
I'm following that. The Pilsen neighborhood is saying this isn't Mexican enough to be here. It's been all over the business pages lately. And how did they respond to that point of wisdom from Jim Hochman?
Well, I don't know if it was a point of wisdom, but I explained to them that the broker's request was in no way discriminatory in a negative fashion, and they should do what was asked so that this broker could lease a number of stores for this particular client.
Mm-hmm.
And they did.
Yeah.
And the client flourished. And as I recall, the broker and the brokerage company did very well representing them.
That's very interesting. Now, there is the instance where you talked about the people in the demographic research basically shrinking from it because they had a blind spot.
Well, they were trained. They were trained not to discriminate.
Right.
And I don't think anybody ever pointed to them and said, but there is a way to use this information for the benefit of the client and to the detriment of no one.
Do you see a similar blind spot that we have, we practitioners of commercial real estate, where we're so hung up on the particulars or the mechanics of what we're doing that if we just looked at it from the opposite direction, we would serve our clients better? Is there something that really comes to mind if I bring up that question?
Are there brokerage companies or brokerage leadership people who get so hung up in what the License Act and the rules seem to dictate that they lose their way?
Yeah, on our side on the commercial side of the equation. Does anything come to mind?
I think I'm going to give you an answer that you didn't expect.
Great.
Commercial brokers, at least the ones I know and represent, truly want to do the right thing. And sometimes they'll ask me a question about, I want to go in a certain direction, I want to do this. What does the law say that I may or may not do?
Yes.
And if I indicate to them that I can't give them an absolute answer, I'd like to call the Real Estate Commission and find out, so that we don't have a violation, we don't do the wrong thing, and we can go forward with a relative degree of comfort, understanding that we're well guided.
That's because you deal with the brightest and the best that know you and would call you. I actually, when I started my company, I called you on a couple situations I remember that came up where I was really scratching my head. Let me give you an example.
Let me finish my thought, if I may.
Yes.
I joking say when I teach, at my age, if you don't let me finish my thought, it may be lost forever.
That's right.
The beef that I have is that some real estate commissions will give you an answer and guide you. The vast majority of real estate commissions are told, don't give legal advice and don't answer questions of licensees. So I find myself trying to learn the right path, do the right thing, and the very regulators who would prosecute a licensee for a mistake or a violation of license law won't give any guidance. So if I were king, I would take all the real estate directors, the senior people in every real estate commission in all 51 jurisdictions, and sit them down and say, you've got to help your licensees as opposed to scaring them to death.
Mm-hmm.
Most of them want to do the right thing. Help them. So that's my soapbox.
I've been actually really pleased with, I'm not remembering Doug's last name at the state of Illinois when I've come up against what seems like an ethical dilemma and ask him how to do this in the most correct way possible. And he's one particular person that I felt I've always been able to lean on. And then if there's a legal subtext there, he'll direct me to somebody who may be a specialist.
One of the tools of the trade is knowing the right people within IDFPR, so you can call and you're a known quantity and you can get an answer.
Right.
Doug is those people.
Doug Seymour. Yes, Doug Seymour. Thank you. That's exactly who it is. Let's track that out. There was a big case in California not long ago. I don't believe in the possibility of conflict-free dual agency. Do you?
I think dual agency can be executed properly, and I think it can be done without conflict. But the key, as the Illinois statute sets forth, is to identify what you can and cannot do for your client. In Indiana, they call it limited agency. They don't call it dual agency, and I think that's a much, much better word.
Okay.
Because it's a limited agency in that if I'm going to be a limited agent on an Indiana transaction, there are certain things I can do for you and certain things I can't. And understand that, and if you don't want a limited agent, you want a full agent, then you should work with someone else. I think it can be done, but there are lots of practitioners out there, such as yourself, who prefer not to run the risk. If I were to list areas, trouble spots for brokers, number one would be failure to understand agency and appreciate whom you do and do not represent.
Mm-hmm.
If I would name number two, it might be having an interest in the buyer or seller or landlord or tenant and not disclosing that information timely to all parties. A third area that I've seen as a source of trouble is when a broker buys his own listing. He's represented the seller. He has all the fiduciary duties to the seller. The property doesn't sell. The broker buys it at a reduced price, probably spends some money to improve it, maybe put some tenants in it, sells at a profit, and the original seller cries foul because he left money on the table.
Sure.
When brokers ask me, can I buy my listing? I said, you can buy your listing anytime you want, but I can almost guarantee you that if you're successful, somebody will sue you. So is it worth it?
Okay.
Welcome to Stages to Success, highlighting individuals who have helped shape our industry in the Chicago area. My name is Chris Schramko, president of the Northern Illinois Commercial Association of Realtors. On behalf of our association, we are proud to sponsor this podcast series. NYCAR provides valuable tools, resources, education, and networking to commercial real estate practitioners throughout the state of Illinois. To learn more about NYCAR and the many benefits we offer our members, please visit our website, nycar.com. Thank you.
Stages to Success can be found on TuneIn Radio, Google Play, iTunes, or our RSS feed. The link can be found at www.stagestosuccesspodcast.com. Try telling your Amazon Echo, Alexa, to play it by commanding, Alexa, play Stages to Success podcast. We're listening to an interview with real estate attorney Jim Hochman of Shane Banks. Do we have any pinnacle billable hours in real estate law that you know of here in the U.S.?
I work for a firm of 25 lawyers, and billable hours run a pretty good gamut from roughly $250 an hour to $750.
Mm-hmm.
I think the lawyers that charge $750 an hour are extremely talented and experienced and can get things done a lot more effectively and a lot more efficiently than some of the younger folks.
So hence, actually, bottom line, less hours spent. So the $750 bought you twice the efficiency, maybe.
Yes.
And is there?
And it might buy some really specialized knowledge.
Mm-hmm.
One of my partners is a retired 33-year alderman who was the author of the Chicago zoning ordinance.
Mm-hmm.
Now, wouldn't you think if your attorney on a zoning matter was Bill Banks, the author of the Chicago zoning ordinance, that his knowledge and experience would make him extremely effective in understanding your problem and getting you what you needed? I charge different rates.
Mm-hmm.
If I have a particular expertise, I'm worth more. If I'm working on a bread and butter deal where I think I'm good, but I'm not exceptional, my rate is different.
Interesting.
I can tell you a story about a very highly credentialed attorney whose negotiating style killed a deal.
Oh, it couldn't be. Okay, tell me your story. I will refrain from telling you my 50, but tell me your story.
I was representing a Japanese electronics manufacturer selling a building in a city west of Chicago.
Okay.
Signed letter of intent, non-binding, price $5 million. We got hung up on a couple of contractual points, and I was working with the general counsel of the seller, and he was reporting to the general counsel in Tokyo for this company. And this buyer's attorney drew a line in the sand, and my client said to me, there's a buyer number 2 out there. Are we obligated to continue to negotiate with buyer number 1? And I gave him an opinion that we were not.
Mm-hmm.
And I called buyer number 2. Buyer number 2's attorney, whom I knew. And I said, the door has opened on this transaction. If you are willing to match this price and sign this contract in 2 days, I'll blow out buyer number 1.
Mm-hmm.
I was traveling, buyer number 2's attorney was traveling, And we, working from separate airports, knocked out that contract.
Yep. So
We made the deal.
Mm-hmm.
We made the deal, so buyer number 2 got the property. Here's where it gets fun. Buyer number 1 was apoplectic, wanted the deal. Buyer number 1's broker, also a client of mine, was apoplectic. I couldn't talk to him about it.
Sure.
When our deal closed, that broker came back to me and said, my people still want the building. They'll want to buy it from buyer number 2.
I've had that happen.
And I said, you are free to negotiate with buyer number 2 or their attorney so-and-so. And do you know they bought that property for $10 million?
That's a decent margin for your client. You did a very nice
So
job.
one lawyer, based on his attitude, his demeanor, and his insistence on a point that we didn't feel was appropriate, cost his client $5 million. The silver lining, and I represent a lot of commercial brokers, I represented all of the brokers on both of the deals, not a conflict, but Newmark Knight Frank Epic represented buyer number 1. NAI Hiffman represented buyer number 2, and CBRE represented the seller.
Okay.
So CB and Hiffman shared a commission on the sale at $5 million. And then Newmark Knight Frank Epic and Hiffman again
Yes.
shared a commission on the $10 million deal. So my brokers did fine.
Mm-hmm.
This was just a lawyer who just killed the deal.
Is there a firm whose work, when you are on the opposite side of the table, you're really watching yourself, or maybe one superstar attorney that you would be comfortable saying, boy, that's always a worthy negotiating adversary?
I'll tell you 2 stories.
Yep.
One of the offices I represented for CBRE was in Indianapolis. It was a relatively new office. And being a new brokerage firm in town, a lot of the owners and developers would take a run at CB's commissions. And Indiana brokers have lien rights, but they sure didn't back then in the 80s. And I found myself opposite an attorney, a very, very good attorney by the name of Zeff, Z-E-F-F Weiss. And he worked for the firm of Ice Miller.
Oh, I know them.
And I remember needing Indiana counsel, and I called Zeff, and I said, I'm interviewing several firms, and I'm tired of having you on the opposite side. I'd like to hire you.
Uh-huh.
And I'm going to be in Indianapolis on Tuesday and Wednesday of next week. Would you meet with me? And he said, I'm out of town those days, but tell me the minute you get back in Chicago, and I'll be in Chicago, and I'll buy you breakfast.
Okay.
And he and I became great friends, started a terrific relationship between CBRE and Ice Miller. Sad to say, Zeff passed away from a very strange and sudden illness years ago.
Mm-hmm.
But that was a guy that I considered a worthy adversary and decided I wanted to make him an ally.
If you can't beat them, buy them. There.
Ally with him.
Ally with them. Well, hire them. I'll
Yeah.
change it. If you can't beat them, hire them.
There's another lawyer out there. This is part 2 to the story.
Okay.
It's really a better, if I may continue. In my 22 years at CBRE, I found myself opposing a very, very interesting lawyer about my age by the name of Marty Schwartz. And Marty had been with a couple of good real estate firms and then went out on his own, and he had a young team of young lawyers working with him. And I considered Marty to be my favorite adversary, not because he was easy, he's tough, and not because he's bad, he's really good. But I'd rather litigate with a good lawyer, an honorable lawyer, a fair lawyer, any day of the week. Marty and I must have had 4 or 5 matters that went to trial. I mean, these were significant battles.
Yep.
About 3.5 years ago, and Marty and I were friends, and we had lunch. And from that lunch came an invitation to join Shane Banks, Kenny, and Schwartz, led by my friend Marty Schwartz.
Oh, my.
I am proud to call Marty my partner today and to work with him on various matters, usually representing brokers. So maybe if you can't beat him, hire him.
That's exactly.
And bring him in the fold.
Yes.
So I consider that Marty paid me a compliment. I consider that I paid him one. And we become even closer friends as a result of my 3 years over here.
Which I think sort of teaches the lesson. I'm in my 50s, and I see some folks in their 30s just willing to go to the mats and destroy another person on the other side of the negotiating table, and you don't know when that person is going to be your managing partner in a firm someday. It's really important how you treat your adversaries, I think.
Let's think about it in terms of a lease negotiation. If you are representing a tenant in a tenant-dominated market, and you beat up that landlord badly, unnecessarily, bluntly, rudely, because you can, don't you think at some point that the leverage will shift, and that landlord is going to remember what a bitter negotiation it was? Don't you think that style will taint a landlord-tenant relationship that might go 5, 10, 15 years? There's no value to it. But I will say this. When I get into litigation and meet opposing counsel, I generally say, let's you and I agree to one thing. You and I don't have a problem. Our clients have a problem. You and I can still work on this as professionals and as adversaries without it becoming personal or inappropriate.
Right.
If my opposing counsel hears that and agrees with me, it makes it a much more pleasant experience. And it's probably a great tool to working something out as opposed to spending hundreds of thousands of dollars and going to trial.
Yeah, and the listeners to our podcasts will hear your comments absolutely echoed by Goldie Miller in her episode, talking about basically bleeding to death a landlord in a healthy market for tenants, and down the road because they won't deal with you again.
I taught a class maybe a year ago, and Goldie was in the class. It was a continuing ed course.
Wow.
And I thought, oh my goodness. It's a teaching skill. If you have a really bright student, you can use that student to teach your course. And I took advantage of having just a wonderful human being of Goldie's caliber and experience in the class. I think she enriched the class for everybody that attended.
Well, your next law review, I hope Ruth Bader Ginsburg shows up, and you can use her.
I hope let me make a political statement. I hope she lives forever.
Ditto. To rewind the tape, you came out of the U.S. Navy. You obviously you were interested in law. You had to go to law school. Something appealed to you about the real estate portion of the law. Did you specialize right away? Did you head into that specialty as soon as you passed the bar?
I was beginning to specialize in law school by taking as many real estate courses as I could. And I was working doing title searches part-time to put myself through law school.
What appealed to you about that? Why not the big Perry Mason murder trials, Jim? Why real estate law?
I'm thinking back. That was 40 some odd years ago. I think I liked the order of property rights. I think I liked the idea of improving the community commercially and residentially, being able to point to something as whether it's development or redevelopment or renovation. I had my fill of the criminal stuff in the Navy. I did prosecution and I did some defense work. And I I did not have a particular desire to represent criminals or those accused of criminal law violations. Might have been fun to be a prosecutor for a while, but I didn't go down that road.
And I'm sorry, man. There's no TV shows about real estate lawyers. You are not going to crack the top 10 episodes of TV with real estate law. That's the bad news.
I'm happy in my little practice world and my little teaching world. I don't need to be on television.
When you came into the focus of the practice, then you're what, maybe in your late 20s, early 30s, and you've started to, you're basically repeating the casework, right? I'm gaining more specificity and knowledge about real estate, whether it's residential or commercial, whatever you were heading into. Was there a case that you look back to, and you don't have to name names, was there a case that you look back on and say, I earned my stripes right there. I learned more from that thing that hardened me, that gave me the edge that I needed to really know that I could be a major practitioner in this field?
Being in-house at Coldwell Banker and then CBRE, I got to focus on brokerage law and property management law. And at the same time, I was able to understand the law of many states, which was my territory. When we had litigation that would go all the way, trial or appeal, I wasn't a slave to billable hours. I was simply a slave to doing it right, sometimes working with outside counsel, sometimes trying the cases myself. There was one case that came into being in 1982 from a 1980 or 81 lease.
Yep.
And defending Coldwell Banker and one of the brokers for 10 or 11 years, defeating the claim at summary judgment and winning on appeal and arguing the appeal, all in-house. The other defendants had some big, very excellent law firms. All but one settled out, leaving one defendant and the CB team. So I was pulling the laboring oar. So that is kind of a watershed case. I could cite to it, and I think I made some law that helps brokers today.
What were the specifics of it that made it, besides the fact that you did a lot of work, what were the specifics of it that made it difficult, that made it hard to navigate, that you overcame? What was it about the case?
Well, you had a sympathetic victim. You had a company that leased a building that had an expectation that it would be served by the railroad. And you had rail cars going through the building and through the property, so it looked like an active rail spur. But the tenant never checked it out, never made a deal with the railroad to serve the property.
Oops.
And the railroad refused to serve the property, so the tenant bailed out and sued everyone. In the midst of the litigation, we found out that the tenant had direct contact with the railroad, had asked for rail service, was told no, and signed the lease anyway.
Ooh. Did you discover that, or did you just put them under duress until they admitted it?
We discovered it. We got documents from the railroad, and we confronted the tenant with that correspondence, and they refused to back down, and we moved for summary judgment, went up on appeal, and it was affirmed.
And you took it all the way through the food chain, all the way to the appeal?
Oh, yeah. Did the appeals. Yep.
How long did it take you?
11 years.
11 years. I'd say you earned your stripes.
Well, that was one of them. The other one that I think about was in private practice, and I was asked to do a broker lien to secure a commission for $60,000 because my broker represented the tenant, and he didn't have a written agreement, but we got language in the lease that confirmed the commission amount.
Okay.
And when the landlord wouldn't pay, we recorded a lien based on being a third-party beneficiary. And we were capitalizing on language that I had put in the Broker Lien Act. And we prevailed, got summary judgment. And once again, the defendant this time appealed, and the appellate court took a long time before rendering a verdict, and they affirmed our judgment. And then this unhappy defendant appealed to the Illinois Supreme Court. Your listeners may or may not know it, but as hard as our Illinois Supreme Court works, it only selects the cases it will hear, and that's probably 1 out of about 20. Mm-hmm. It took 2 years for the Illinois Appellate Court to render an opinion. It took about 2 weeks for the Illinois Supreme Court to say no thank you. And when the dust settled, and by the way, when you appeal a judgment against you, you have to put up a bond to prove you can pay the judgment. When the dust settled, my client collected $192,000.
For a $60,000 commission?
$60,000 commission that earned interest pre-judgment at 5%, post-judgment at 9%, and recovered 100 cents on the dollar of its attorney's fees.
Nice work. Nice work.
I like to tell that story. It gives broker lien claimants the courage to fight the battle where they should.
Jim, it's been very informative. I thank you so much for giving your time years ago with the lien stuff that you worked on our behalf, and then giving your time here to the podcast for our listeners who are brokers and landlords and people just interested in the industry in general.
It's been my pleasure. I point out to you there are 34 states with lien rights, so I guess I've got 17 more lien acts to write before I hang it up.
I hope you enjoyed today's interview with real estate attorney Jim Hochman of Shane Banks. I'm your host, John Hunter. Digital editing and technical assistance from Monty Scott, and recorded at the studios of Chicago Public Media at Navy Pier. Join us again for people and stories from the worlds of the symphony orchestra and commercial real estate for our next episode of Stages to Success.